Well, colleagues, good morning. My name is Jan Drahokoupil. I'm Head of Sector Analysis and Risk Assessment in the European Labour Authority and currently also Acting Head of Unit Enforcement Analysis in the European Labour Authority. So I come from, I think, quite a different world than the world of aviation. I come from the world of enforcement of labour law and social security regulation, and I wonder if this world is as fascinating for you as your world is for me, the world of aviation. And so I was very interested. I found it very interesting to listen to the presentation discussion this morning, and it's great to be here and have the opportunity to talk to you and interact with you. So many thanks for this opportunity to speak to you. This is one of the first collaborations between ELA and the EASA, so I'm looking forward to the future opportunities for collaboration. Now, you may wonder what's the link between our work and the world of labour mobility and social security coordination and the flight time limitations. More broadly speaking, for us, the key link is between the aviation safety concepts, most importantly the concept of home base and the determination of the application of social security legislation and also labour law. Then more specifically, the way the flight time limitations anyway come to our mandate is through the working time regulations. So we are mandated to enforce working time regulation when it comes to, particularly to the posting of workers. This is quite narrow field and narrow topic, but when it comes to our actual work in practice, the authorities that we work with do look at the aviation sector and the work time and the application of the work time regulations and do enforce that. They don't focus on the airline crew specifically, but all employees in the airlines. And this is, in a way, the main link. But to be honest with you, I will not speak today about working time regulations much in detail. Rather, my aim is to let you know about our work on the aviation sector, on airline crews in particular, so that you are aware of our work and know when to look at ELA and go to ELA for information or for anything that would be relevant for your own work. So what I want to do today, this is a bit, but too early. Yeah. What I want to do today is actually first a little bit explain to you who we are, what we do, what our mandate is, and how it's relevant or linked with aviation. And then I want to speak in more detail about a report that we currently prepare, and that we also cooperate a little bit with the EASA, which focuses on specifically on the situation of enforcement in the context of CAT, civil aviation, commercial aircraft transport sector, focusing in particular on the airline crews. Now, yes, I pressed the right button this time, so there's learning. The European Labour Authority goes back, it's a young agency, it's one of the youngest agencies in Europe. The history goes back to a State of the Union speech by Juncker in 2017, where he argued in the European Parliament that he finds it striking that there is a banking authority to enforce regulations in the financial sector, but we don't have anything in the world of labour. And then in 2019, the authority was established through its when the ELA regulation was adopted. And I have here a quote by Juncker at the inauguration ceremony of ELA in 2019, where again he reminded of or argued that indeed observed that the mandate of the authorities to work towards a fairer and more efficient European labour market, particularly as far as the mobility is concerned. The issue that we face there is that this is an area which is very complex when it comes to the actual rules that we have and also the enforcement of these rules, because we have, as I will show you later today, we have a large number of authorities that are responsible for enforcing the applicable legislation when it comes to labor mobility and social security coordination. And this large number is in each country, and then the authorities also need to cooperate across Europe when they enforce the legislation, and therefore a need for someone who will, or an authority to support or provide resources which allow the collaboration and joint enforcement on the European level. And eventually, by achieving a level playing field, making sure that we don't have some companies undercutting others by not complying with the applicable legislation, it's the business in general and citizens who should benefit from a fair and more effective enforcement. But as I will also show you, it's not just about enforcement, Eli. We also large part of activities are about information provision. As I mentioned to you, the rules are very complicated, and businesses and citizens often struggle for good reasons to understand what they should comply with when it comes to social security and labor law. Now, the areas of our competence, it's 4 legal instruments. One first is the free movement of workers, which is, I think, most simple to understand. Is the provisions that allow us as European citizens to seek and take work anywhere around Europe. Then the posting of workers, which are the provisions which allow companies to provide services across Europe by using the workforce from their home country without having to deal with regulations and well, I wouldn't say without having to deal with, but by being able. These are the provisions that allow companies to provide services while using the workforce from their home countries. The nature of these regulations is such that they do need to comply with some of the provisions of the countries where they provide the services, but they can use the employees in their country, from their home countries using also, and keep them being enrolled in the social security coverage in their home country. Then we also are responsible for the enforcement of regulation when it comes to social aspects of international road transport, and finally the regulations related to the social security coordination, which allows us to the continuity of coverage when workers move from one member state to another. And finally, tackling undeclared work, that's not a legislative area. It is an initiative which preceded ELA, through which member states share their experience in tackling undeclared work. So in these areas, we develop a range of activities, starting with information of services to inform workers and employers about the applicable regulations and what they need to comply with. We also help European Commission to run the EURES system, which is a system which links public employment services across Europe. So it allows job seekers in one country to have access to opportunities in other countries through the local public employment services. Then finally, the activity which is dear to me, because this is my unit, we organize or help member states to perform inspections on the European level. So to enforce these provisions, the legislation in our competence, usually authorities need to work together. And when it comes to more complex cases, they need to organize jointly inspections with participation of inspectors from 2 or more member states, and we make that possible. Then there are other areas of supporting cooperation between national authorities, and also we organize a range of training and capacity building activities which target public officials, in particular, but also social partners. But our main target group, in a way, is the public sector colleagues. Then we also perform analysis and risk assessment. That means risk assessment on the level of individual companies to support the inspection activities, but also analysis more broadly about sort of issues faced in the sector. And I will talk about one of these analyses today, which focuses on the airline crews. And finally, we also support member states in digitalizing their services related to labor mobility. Right. When it comes to aviation, we have not been. It's not a sector where we have focused on to a large extent so far. We have seen several, actually quite large cases that we supported when it comes to inspections. So that is quite important when it comes to activities. Then, when it comes to cooperation with member states and social partners, we supported, I think, 3 workshops on the aviation sector. 2 in 2023, another one in 2024 in Tallinn. I believe that Croatian civil aviation authorities took part in that workshop, so that I appreciate. And the last activity is what we now develop. That's this report on airline crews. I will talk about right now, indeed. So why we do this report? Well, civil aviation is obviously for us an important sector, given the importance of labor mobility in the sector. So people who work in the sector often are mobile, not just through the virtue of flying in aircraft, but they often are posted or are moved around Europe by their employers, or they seek work in other countries. This is very common in the sector. Therefore, our focus on the sector. At the same time, when we decide about which sector to focus on, we also need to take care the interests of the stakeholders, and that's why we started with these workshops, where we assessed demand in the of our stakeholders and also civil aviation authorities for our activities in this sector. So in this report, we actually try to understand the structure of employment and the business models that characterize the sectors, and how these interact with the applicable legislation, so labor mobility and social security coordination provision. And in this way, we wish to first identify the issues that the national authorities face when working in the sector. Second, we provide guidelines on how the applicable legislation applies in the sector, how it interacts with sector-specific provisions, particularly the safety regulations. And in this way, we also prepare grounds for planning future activities in the sector. So the focus of the report is threefold. First, we provide an overview of EU rules under our mandate and how they apply to the sector. Second part of the report identifies enforcement authorities. As I mentioned to you, this is a major issue that we see also in the inspections, that authorities struggle to see Even on the national level, often they struggle to see who does what actually in the sector, who is responsible for what, but it becomes even more complicated when they need to find a partner in another member state. So this report will provide some sort of a directory of who does what in which member state. And finally, we sort of collect challenges that member states face. We did a sort of survey of authorities and also a number of case studies in countries where there is experience with enforcement in the civil aviation sector. So I'll start with this. We are quite advanced, but when it comes to the report, I'll first look at so I would like to share some of the insights on the legal framework, how it sort of interacts with the safety regulation in the sector. Now, as I mentioned too, it's three legal regimes that we deal with and which are applicable to aircrew. The first one is the free movement of workers, which applies to aircrew members in the same way as it does apply to any other worker in the EU. And we do indeed see that many workers in the sector do exercise their right to seek employment in other member states. And that, from the enforcement perspective, what's relevant for us are the rights against discrimination when they see work based on nationality, when they seek employment in another member state, and the right to equal treatment once they are employed, which also covers the conditions of employment and working conditions of employment and work, and including also remuneration. Then there's the posting of workers regulation. There the situation is a bit more complicated because much of the mobility, of course, that the workers in the sector perform when they perform their duties doesn't trigger the posting provisions. We also see that a number of member states have implemented also derogations from the posting of from the obligations in the posting of workers directive. So Belgium, for instance, exempts aircrew flying internationally from posting rules, except for cabotage operations. Austria waives obligations for intragroup posting under 2 months. But it is an area which is actually quite complicated when it comes to enforcement, and the situation when the posting rules are triggered, for instance, when the workers are when the home base is when the home base changes, for instance, for the holiday period or for the peak periods or for low demand periods. It's quite a complicated assessment that the authorities and the employers need to perform, and also depends on national regulations. So this is an area which we cover in this report to provide some guidance in the application of when the posting provisions apply also to airline crews. And the third area is the social security coordination rules, which provides exception to the lex loci laboris, so the principle that the social security of the place of employment should, or place where the work is performed, should apply, but the social security coordination rules allow exceptions, so that it's the home country regulation which should apply, and for this the home base is a key criterion for determining the applicable social security regulation. Now, I would like to a little bit just introduce this notion of interaction between the home base regulation and the three areas of our competence. As you will know, the home base is a legal concept which comes from the aviation safety rules. It's set, it's mandatory for the operator to assign a home base, and it's in a way a decision by the operator which home base is declared. It's defined as the location assigned by the operator from where the crew members normally start and end a duty period. So this comes from the aviation safety rules, but then the Social Security and labor law, borrowed this concept and also uses it in assessment of which is relevant in that area. So when it comes to the Social Security coordination legislation, that refers explicitly to the concept of home base in determining the applicable Social Security regulation. So it's the regulation of the home base which should apply when it comes to Social Security. Now, in the safety regulations, home base is declared by the operator, but this act of the declaration is not binding on the authorities. So when it comes to actual enforcement, the labor inspectorates or social security institutions are not bound by the declaration of the operator. They may rule that de facto the home base differs from that which is officially signed by the operator, and for that the labor inspectorates or social security institutions usually need collaboration with civil aviation authorities to get the information and data that they need. They have tried to obtain it typically through inspection activities, through interviewing worker, the employer, but they typically need the collaboration with civil aviation authorities to establish the home base, to see the contractual situation, and to see also the flight patterns of the crews concerned. Then the home base is also relevant for the posting legislation. As I mentioned to you, this is something where it's quite difficult to interpret how at which stage the posting rules should be triggered. The posting rules essentially say that when the services are provided across Europe, there is a home country where the workers remain insured, but when it comes to the conditions of work, it's the host country rules that apply. So when it comes to remuneration, working time regulation. But it is actually not trivial to then determine for both employers and also enforcement authorities at which point the host country provisions are triggered. So when, for instance, the home base changes for 3 months, does it trigger the posting rules? I hope that you will not ask that question today, because I will have to say it depends really, and I refer you to the report. But again, the home base is relevant for enforcement authorities and also for employers when they are assessing how to apply the applicable legislation. And finally, there's also a link with the habitual place of employment, which is not a sort of EU labor mobility legislation, but it's a Rome regulation which applies more generally to the labor contracts, and which has provisions on which labor law should govern employment contract, and that basically says that it refers to habitual place of work, that would be the home base, but it also says that workers and employers are actually free to choose if they agree. They can agree on which legislation will govern the employment contract. And here we have the interesting case law in the European Court of Justice, Nogueira and others from 2016, which was a case of airline crew with home base in Charleroi, who had had Irish employment contracts, and there we saw the European Court of Justice ruling that it's the case that the place of work indicates just one indicator, or home base is just one indicator, which is relevant for determining the habitual place of employment or the law that should govern the contract. But since in this case the choice of the Irish law was detrimental to the interest of and protection of workers, since they could not access justice in the Brussels courts, which would provide them better protection, the court ruled that the Belgian law should apply to these airline crew workers. So when we look at the actual practice, we do see when we get input or feedback from national authorities, a majority of them would do find the establishment of the home base a challenge in the enforcement practice because of the quite complex legal or contractual arrangements, arrangements such as wet lease. And in this report, we discuss, introduce to authorities the various business model contractual practices and discuss how the applicable legislation is applied in these contexts. And this is a response in a way to the challenge of members of national authorities to actually establish what home base is in the inspection practice. The key to success there for national authorities is indeed cooperation between authorities that are involved in enforcement, and also on the national level and also internationally. For labor inspectors, the key issue there is indeed to get information on the flight patterns, on the contractual arrangements from civil aviation authorities who do have access to that information. But in practice, this is something that we wish to support authorities in working on by establishing structured models of cooperation and also by providing guidance and training. Very briefly on some insights from that directory of competent authorities. Just a map showing the large number of authorities. I'm not sure if you can see it, but the red countries are where even I can't see it. 5 to 8 authorities on the national levels are responsible or share responsibilities for enforcing labor mobility and social security coordination legislation. So you see the challenge for authorities when it comes to the enforcement. The average is 4 per country. Typically, it's labor inspectorate. And labor inspectorate, of course, would be primarily responsible for labor mobility provisions. Then the social security institutions for social security coordination. Tax authorities are relevant for enforcement. Then civil aviation authorities. In most member states, they focus on safety regulations, but there's a number of member states where they also deal with labor mobility provisions, and they are essential also for providing information to labor inspectorates, which is crucial for answering these questions I discussed today. And finally, the immigration services. So when we organize an inspection in aviation, it's often 4 authorities per member state. Now imagine there's 3-4 member states involved. It becomes a bit complicated. I will skip this one. And just some insights from the survey of issues faced by authorities. Here is what the most sort of frequent challenges face in cooperating at the national level. The first one is accessing information from other authorities, the typical situation being labor inspectorates, social security institutions needing information from civil aviation authorities to establish home country, host country, determine application of the posting rules. Then we also get quite popular the compliance with General Data Protection Regulation. To me, this is a bit of it's a part and parcel of the accessing information, because often when there are challenges, colleagues and authorities have a tendency to say, oh, it's GDPR, that's the reason why we can't find a way. Then another challenge frequently mentioned by authorities in this is the basic understanding of the division of tasks and competences, who does what on the national level and also particularly internationally. And the last one is also linked to the first one, providing information to other authorities indeed is a challenge that we work with member states to overcome. So some of the additional insights from the authorities on the challenges and the way forward. The first, so 3 of them I have here. The first is that indeed the correct application of relevant EU rules needs to consider the interaction of several legal regimes, including the aviation safety rules, social security coordination, and posting. And I was trying to give you some of the bit of a taste of what the challenges that we face there. Second conclusion there that we see in the report is that given the complex contracting chains, we see the responsibility and liability is spread across a number of actors in the sectors. This includes airlines, various intermediaries, temporary work agencies, aircrew members, and when we have these arrangements such as wet lease, for instance, the lessor as well as the lessee is liable for the compliance with EU labour, social security and aviation safety rules. When the temporary agencies are involved, they have also obligations that they need to comply with when it comes to social security coordination rules, such as the issuance of PDA1 declarations confirming the enrollment in a responsible or relevant social security institution. And finally, call in a way for further guidance and training, and this is what this project leads to. We would like to indeed, in the cooperation with EASA, provide not just a sort of a stock of issues faced by authorities, but also guidelines and checklists which to guide them in the actual inspection efforts at the airports. So some of the conclusions, the first one, member states indeed call for further guidance, as we observe in the report, on the concepts such as home base, habitual place of work, operational base, and posting as is applied to aircrew members. And there's a clear importance of understanding the link between aviation safety concepts and the applicable social security regimes. And ELA will provide, indeed, guidance on that. Second conclusion we find is that labour and social security authorities often lack timely information on operating basis, flight rotations, contractual arrangements, and for that we need to improve the data sharing agreements between with civil aviation authorities. Third, we observe this fragmented landscape when it comes to institutions responsible for enforcement, and including labor inspectorates, social security institutions, tax authorities, aviation authorities, migration authorities often, and therefore we need to establish on the national level a structured mode of cooperation, and we do provide some examples, good practices of how this can work effectively in the report. And finally, when it comes to the information provision to actual operators and workers, there we also we see a gap in terms of lack of user-friendly or something one can actually digest guidance on the application of relevant legislation. And that, I think, that's what I have, and I'm quite happy to answer any questions if you have. But please don't ask me about how to trigger or when the posting rules trigger in your country and in your situation, because that would be a very long discussion.
Maybe the easiest thing is it's just you and me. Is if you want to use that microphone, and I'll use this hand one.
Yeah, let's do that.
And then we do it that way. So if we could get the questions, actually the first one that maybe we do a little bit together. So the first one is, when labour practices indirectly influence fatigue risk, how do ELA and EASA interact, and how can stakeholders engage with ELA in such cases? So I know the two organisations we have collaboration, but I think this is probably a really useful for those who don't know. Every 3 years, the agency is required under the basic regulation to do a report on the wider impact of what we call socio-economic factors impacting aviation safety. That report is just going through the final consultation now with various organisations, etc., and is due to be published in the next 2 to 3 weeks. So I think it's worth usually kind of referring to that ultimately, and that's part of an ongoing process then. And there'll be a number of actions that will kind of address that. I don't know if there's anything else you want to add on that first one.
Yes. Well, indeed, we assume we don't focus on the fatigue risk, and for us, to be honest with you, as an authority, when it comes to work time regulations, for us it's not relevant that better enforcement, what it leads to, right? This is a motivation for having that in place, but for us, we are concerned with making sure that what's in the book is applied. So we don't do actually work on the link between the fatigue risks and the compliance. That's something we would leave to EASA, I think. Yeah. But for us, this is important to and then the engagement. We organize a number of, the first engagement that we offer is indeed the report will be published, and then the next stage we would like to work on the guidelines, which should be also available for, not just for the authorities, but also for the employers in the sector. And then there's a number of stakeholder engagement activities where we typically engage through employer and worker organizations on the European level. So that's how to get engaged.
Fantastic, thanks. So we go to the next one. How does work with self-employment contracts where operators do not support social contracts in the habitual place of work?
Yeah, this is a key theme, but I should emphasize that our model is it's a demand driven agency. So once there is a demand from member states to work on the enforcement of bogus self-employment, we will support it. We of course encourage we have means of encouraging coverage of some topics and themes in the enforcement activities. We do actually encourage the activities on bogus self-employment, and we do actually see when it comes to the cases in aviation of inspections, they do tackle bogus self-employment, but in the end it's a choice in member states.
Thanks very much. So that covers actually those next two. Then we had within the EU, are you allowed to have under the same work in contract, 2 different home bases in different periods of time? For example, 6 months in France or 6 months in Italy. It's quite a specific question.
Yeah, I will refer you really to this to the report which covers exactly these questions. But it is,
Yeah, indeed. The bogus self-employment we've covered. AOC in a European country, crews based in a second European country, which labour laws apply?
yeah, I will not answer these questions because for me it's a bit of minefield. I'm not.
Yeah, it's a bit of and a lot of this is where I say a lot of this will be covered in much more detail in the Article 89 report and then the follow-up. So, yeah, I know quite a number of the organisations in this room, particularly the staff representatives, have been involved in that. So, does ELA cooperate generally not only in aviation with work and organisational psychologists?
No, we don't.
No, and there's and actually it's something there's a health and safety agency as well that does workplace health and safety that does have. When we talk about psychological health or psychosocial health and safety and the work we've been doing to promote well-being, that's something where we then have a link with the Health and Safety Authority because then it covers beyond aviation. And actually we also have collaborations with the other transport agencies, so with the rail agency in Valenciennes in France and with the maritime agency in Lisbon, to look at particularly things like psychosocial health and safety, organisational psychology in that context, in other transport domains as well. So, yeah. Fantastic. Thanks very much.
Well, thank you very much.
Appreciated.